Hi everyone, welcome to episode 59 of the Immigration Lawyers Podcast, weekly review of September 18th through September 24th. Obviously the big news is Travel Ban 3.0 that came out yesterday, Sunday night, and we're going to go over some details of that. Obviously it's still fresh and not sure exactly how it's going to play out in reality, but I'll go over some points I noticed that are interesting to talk about. Probably going to be talking about this more and more as it comes into play, the lawsuits happen, and people actually try to get these visas, and we see what happens at the embassy. Before we start, I've officially begun the Facebook page for the Immigration Lawyers Podcast and its companion, the Immigration Lawyers Listserv. I created a Facebook page called the Immigration Lawyers Listserv for immigration lawyers to discuss, whatever kind of immigration thoughts they had. Wasn't that active. I decided to make it into a forum where we could just potentially or primarily shoot out information that comes to us. For example, in Los Angeles, I'm getting marriage cases approved in 3 to 5 months, but in Las Vegas, it's taking twice that. Well, if you're in Minnesota or Texas or Florida in particular, because I have a couple of cases there, I'm interested to see how long it takes you. So any type of information you could share to our group, I'll be happy to, I'd love it if you could post on that Facebook page. It's open to immigration lawyers, so just email me if you wanted to join or find it on Facebook. It's the Immigration Lawyers Listserv, and if you email me, I'll try to find how to send you a link. My email is info@jqqlaw.com. I think it's going to be a great thing to share information about practice, about the law, and everything we can to make each other better at what we do every day. Without further ado, let's get started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. So the Travel Ban 3.0 started. It's much better written and with better legalese than the previous ones, and because of that, I think it's going to be more difficult to challenge in court. Particular, it set standards that are separated from the emotional and racial and ethnic and religious based discriminatory ideas and points that could have been made in the previous travel ban. This one was part of a review where the Secretary of Homeland Security established global requirements for information sharing in support of immigration screening and vetting. So it's objective, in their views at least, objective reasons why these countries have to have visa bans on them. And there's been changes. Now, me personally, I think the ban is a geopolitical issue more than it is about security. I think especially because they included this time North Korea in there with Iran, still don't have the real countries that support terrorism or in the region as part of that group. For me, it's a military and geopolitical reason they're doing this, and there's more behind the scenes on that. But just for immigration law purposes, they've kept Iran in there, and we're going to go over the rest of the countries as well as I go through some notes I made in the travel ban. So primarily the issue is this: they're saying that these countries aren't sharing information and don't have good security checks and internal checks and all that kind of stuff to allow people from these countries to get visas. They're going to constantly review the visa programs, I think, every 180 days. So people can leave the list, but at the same time, there's like dozens or a dozen or more countries that could be entered into the list because they're not really matching up to what's necessary for U.S. security and visa requirements. One country that was left out is Iraq. They said that although Iraq is not meeting the standards, I guess when they're a coalition partner and the U.S. has a base there, all this kind of stuff, they have to kind of play it safe and include them and take them out, that is, and include them within a group that could get visas, but they're going to get heightened scrutiny in the process. So the countries that are basically there now are Chad, Iran, Libya, North Korea, Syria, Venezuela was added, and Yemen is still there. These countries have no additional security risks and additional security reviews that are required. One country that was included is Somalia, where they said they are participating and cooperating with the U.S., but because of issues that they have with combating terrorism and the like, they're still included in the travel ban list. Now, I'm not going to go through every country and detail out what specific issues they have. other than Iran, because that's, of all these countries, has the most amount of immigration in the United States, frankly, and it's something I have to deal with on a regular basis. But one note to make with regards to other countries, for example, when looking at Chad, it says, the entry into the U.S. of nationals of Chad as immigrants and as non-immigrants on business and tourist B1, B2 visas is hereby suspended. So when they say, immigrant visas and non-immigrant B1, B2s are prohibited, does that mean H1Bs and L1s are allowed? That is kind of weird that they wouldn't allow an immigrant, a green card holder, potential green card holder to come, but a non-immigrant L1 could come. Also, they specifically talk about the entry of people under these visa categories is suspended. So it leaves the impression that visas could be made, but it's essentially they can't enter the U.S. and CBP could block them. So the wording there was a little off because there's other parts that say, a consular post could issue a visa waiver. So does that mean, a waiver for this situation? Does that mean a consular post could still issue the visa, but it'll be a banned visa? Probably not, but the language there to me was a little off. Now going to Iran, they essentially cut off all immigration from Iran of all kinds, except for some exceptions for student-type visas, F, M, and J visas, which will get heightened scrutiny, which they've already been going under with administrative processing and the like. But they're stuck. So until some sort of change happens, K1 fiancé cases, marriage cases, those are going to be initially denied unless we're going to go into exceptions and waivers could apply. Section 3 of the Travel Ban 3.0 goes, and they call it a proclamation here, is about scope and implementation of suspensions and limitations. So this only applies to foreign nationals of designated countries who have the following. 1, are outside of the U.S. on the applicable effective date under Section 7, which is September 23rd, I believe. 2, they do not have a valid visa on the applicable effective date, again, yesterday, September 23rd. And 3, and is the key here, and 3, do not qualify for a visa or other valid travel document under Section 6D, which we'll briefly talk about later. So they have to have all 3 of these. So I believe if someone already has a visa, and again, this isn't a legal guidance for non-practitioners, it's just thoughts for immigration attorneys. I don't want to be held back by this, but I believe that if someone already has a visa and it's approved, for example, I have a client that luckily got their visa approved last week, that means that they could enter the U.S. with that visa and this travel ban shouldn't apply to them. However, I've told them to just get in the U.S. as soon as possible because of all the various issues that exist. Now, there are also exceptions, just like the Travel Ban 2.0 had. The ban doesn't apply to lawful permanent residents, any foreign national is admitted or paroled in the U.S. On or after the applicable effective date, any foreign national who has a document other than a visa, such as a transportation letter, an appropriate boarding fall, or advanced parole. Dual nationals doesn't have that applied to them if they're using the other nationality's passport. Certain diplomatic visa types, and those who've been granted asylum by the United States, and any refugee who has already been admitted to the U.S. Now, waivers are possible, and this is going to come in, and I haven't seen it done because the last travel ban, the Supreme Court kind of opened it up, but on a case-by-case basis, consular officers or CBP officers can review waivers, and the waiver may be granted only if a foreign national demonstrates to the consular officers or CBP officials satisfaction that A, denying entry would cause the foreign national undue hardship, B, would not pose a threat to the national security of the U.S., and C, entry would be in the national interest. So the national interest, what is the national interest? That's vague. For example, I have a client right now, woman coming to the U.S., parents are dying, they're U.S. citizens, can't go back to Iran, they're from a different religious faith, and they go there, they can kill them. So, it's undue hardship on the daughter, in my opinion, to not have her receive the ability to come see her parents maybe one last time. So I'm going to make that argument. Hopefully it works. Have medical documents from the parents, religious documents showing that what their faith is, and that they were asylees, so they can't go back home. All that. Now, entry would not pose a threat to national security. I think they just look at the person and maybe do administrative processing and check that out. So that's a young woman. I don't see why that would happen. Third, entry would be in the national interest. I'm not sure how to argue that it's in national interest, other than maybe saying, just top of my head, a U.S. citizen will be happy. It's a national interest for U.S. citizens to be able to meet their family and all this kind of stuff. So these are vague standards. It's really going to be a case-by-case basis of what the officer wants. Now, they say the guidance issued by the Secretary of State and the Secretary of Homeland Security under this subsection shall address the standards, policy, and procedures for A, determining whether entry of foreign national would not pose a threat, blah, blah, blah. Determining whether entry of foreign national will be a national interest, Bob. I'm guessing we're going to get further guidance later. Addressing and managing the risks of making such a determination in light of the inadequacies in information sharing, identity management, and other potential dangers posed by the nationals of individual countries that have these restrictions. So essentially, these countries aren't participating, helping the U.S. out. How are they going to check these things? D, assessing whether the U.S. has access at the time of the waiver determination to sufficient information about the foreign national, blah, 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 and determining the special circumstances of justify a waiver. So that's pretty vague, but essentially they're going to do more research and find more guidance. It goes on to say, case-by-case waivers may not be granted categorically, but may be appropriate subject to the limitations, conditions, and requirements set forth under subsection I of this subsection, and the guidance issued under subsection 2 in individual circumstances such as the following. So they're going to look at foreign nationals previously been admitted to the U.S. for a continuous period of work, study, or the long-term activity, and is outside during the effective date. That might be one thing they're going to look at. And if they're coming back to resume that activity, then I guess this goes to a lot of the business visas or employment-based visas. The foreign national has previously established significant contacts with the U.S., but is outside the U.S. on applicable effective date. C, the foreign national seeks to enter the U.S. for significant business or professional obligations, and denial would impair these obligations. So that is an explanation of the undue hardship. A lot of people come to the U.S. to business, research, conferences. That could help with that. The foreign national seeks to enter the U.S. to visit or reside with a close family member, spouse, child, or parent who is a U.S. citizen, blah, 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 and then denial will cause the foreign national undue hardship. So they go and say it's okay to see, that's good actually to be a family, that's going to help, but the undue hardship is still kind of vague. Now, foreign national is an infant, a young child, or adoptee, an individual needing urgent medical care, etc. The foreign national has been employed on or behalf of the U.S. government, etc. The foreign national is traveling for purposes related to international organization. Let's see a couple more. The foreign national is a Canadian permanent resident who applies for a visa at a location within Canada. The foreign national is traveling as a United States government-sponsored exchange visitor. I guess that's the, I forgot the title of those. Something scholars. And J, the final one, the foreign national is traveling to the U.S. at the request of the United States government or agency, blah, blah, blah. So those are the exceptions and how the waiver system works. It looks, it's just going to have to see it. I'm getting calls on this a lot. Obviously all of us are within 24 hours. I really don't know how strict they're going to play this, and if some embassies are going to be better or not, or if they've been ordered internally to be strict or easygoing. Maybe Trump just wanted this to be out there to appease the base, but he's not going to be as hardcore. I don't know. Really have to wait and see how this is going to play out. So that was a quick recap of travel ban. I wish I had some travel plans. Travel ban 3.0. I don't know how it's going to work out, and I've been getting a lot of calls on that, and I tell people, I don't know, we'll try our best, we'll see what happens. But along with that travel ban, it's the whole issue of the 90-day misrepresentation assumption that the State Department is going to make for people coming on the visa waiver has been a big problem. I had to turn down several adjustment cases this week, and I was very disappointed because it was like a lot of cases to just put down a couple of days. People on the 60th day want to get married, adjust, from Commonwealth countries, Western Europe, and the reality is I had to be conservative and tell them I don't recommend filing for adjustment of status in the visa waiver program. If you file within the 90 days in California, it's good because you get that court protection, but if misrepresentation somehow comes into play, that could be a big problem. And if they overstay 90 days, I've stopped really doing those at this point too, because what's going to happen if ICE wants to crack down and be waiting for them at the USCIS field office? They haven't done that before. I've heard anecdotally this happening, but if someone does overstay the visa waiver program, technically ICE could come and pick them up and take them away. Up till now I've been adjusting these with no problem even if it overstays, but I can't take on a client with that kind of responsibility and tell them it's going to be okay. And even if they want to risk it, I'm not sure if I want to just have that on my hands. So I'm recommending going back to your home country, do a K-1 if you're in a rush, or get married, and if you have a history of relationship, do an immediate relative petition. It's going to take a while, but I just don't want to mess around with the State Department accusing you of misrepresentation at this point. Maybe in a month when we see how this plays out, that'll change. But with people on a visa waiver program only 90 days, waiting a month is not realistic. They could go back home and then come to the U.S. again with a visa waiver, wait another 90 days and see what happens. That might be the way to go, but that in itself has some intent involved, so I couldn't recommend that as well. It just sucks, to be frank. I wish it wasn't the case. Now moving on, there was another LAX quarterly CBP meeting, and it's a great meeting. The people at LAX, the officers there, especially the chief staff, the chief staff that they have there are just exceptional people. I'm so happy that we have a team that's so caring and willing to meet with lawyers and discuss things with them. A couple of good points that came out from the meeting that were interesting is, one is they've increased the fee that airlines have to pay if they allow someone to board that wasn't supposed to be able to board and enter the United States for various reasons. They have a proper boarding document, etc. They've increased that amount to $4,300 a person. So you best believe that airlines are not going to want to board people. I saw someone on the listserv said that they had a client that was a green card holder with a green card stamp in their passport because their I-90 was pending, and British Airways wouldn't allow them to board. So the fear is strong. I have a client who's actually, his job for the airlines is that when someone is not permitted to board, he has to sit with those people that are expeditiously removed on the plane and be with them when they fly back to the third party country or the home country, wherever it is, and come back. So airlines not only have to pay $4,300, they have to take 2 seats out of an airplane for their own person and the applicant, and potentially a family member or something like that, to export them. And there's all sorts of costs involved with that. So you're going to see a lot of cracking down and unnecessary crackdowns on this issue. Now, I mentioned before, there's this program called the Carrier, what is the program called? The Carrier something guide. Apparently, a Carrier guide, I can't remember the exact name of it, but if a traveler is not allowed to board, they could tell the airline to contact this group that connected with CBP to get verification that the person is allowed to board the plane and enter the United States, because if this problem happens, they're going to be stuck at the airport. So this exists. The travel person, the booking agent or booking person at the airport might not even know about it, ask for a supervisor, but it's possible. I haven't used it myself, but that's what CBP tells me. They could call this group and look into it. One note is, the CBP actually got sued by ALA for this document. We have the Adjudicator's Field Manual for the USCIS, we have the Foreign Affairs Manual for the State Department and Consular Processing. CBP had a manual that they released, but they wouldn't allow the updates to come out. They wanted it secret, and the ALA sued them, and that created a bad blood between them. But the old one still exists, and it's worth finding the internet and reading. The reason I came up is I was talking with them about a case I have right now where the person is in social media, might be a way to put it. And essentially, he always has a camera on him and moving around. And he was denied entry a few years ago for potentially working in the United States. And I said, why is that? Why would you do that? All the editing of the footage and the social media posting, all that was going to happen overseas. Why would you stop this person? There's a case that's in, the important case that they judged B1, B2, their tourist visa, business tourist visa stays, was a Hong Kong tailor was coming to the U.S. He would measure his clients, go back and do the work in Hong Kong. And I said, this is the same thing. And they challenged that back. They said, look at the field manual. It has an example of a freelance journalist who comes to the U.S. and just being here is considered work. Now, for social media, this person advertised social media, and they get paid through the social media forum, the online forum. So they said these companies are located in the U.S. and checks cut by U.S. company for their presence in the U.S. and the activities they're doing. So that automatically is going to be a violation if they have if they're going to post. So my idea is if someone's going to be coming on social media, they have to maybe shut down the accounts or do a blast that says, listen, I'm going to be in the U.S. negotiating contracts. I'm going to have to show old videos of myself and old new posts, or I'm just have no activity during this 10-day period I'm in the U.S. To be safe, I guess that's what you have to do to avoid CBP really cracking down on you. It's a weird thing, and technology moves faster than the law is, and I think that's a big problem in these areas, and it's just going to get worse and worse. A quick note. When someone is coming to primary and they're talking with the officers might ask questions, but they rarely actually take notes up on the computer. So probably an applicant or traveler is not going to have any notes in the system. There will be notes if they got a visa from their consular appointment. The officers at the consulate and the embassy will take notes, and CBP has access to those. But CBP rarely adds themselves at primary. But if they're moved to secondary, that's when notes come in. So keep that in mind. If your applicants and they're adjusting status in the U.S. and you talk to them and you ask what'd you say, if they said something primary, probably no, that's not going to be anywhere. But if they go to secondary, there might be a chance of things written down. Also, there are times when a person on their I-94, for example, on a tourist visa, gets less time than the 6 months that was expected. CBP officers in primary are not allowed to give less than 6 months. They could increase and give a year if someone comes in requesting it. They have authority on their own to do a year, but they have to go to secondary to give less than 6 months. So if that happens, definitely, if it makes sense, talk with CBP about it, try to fix that up. That shouldn't be the case. Also, if someone has a check in there, I'm not sure who would have this, but if, for example, you have a check that's endorsed, ready to deposit of more than $10,000, that's considered a cash instrument. So in that part where you do customs, they ask you have $10,000 or more. If you have a $10,001 check on you that you're going to deposit at the bank when you come back into the States, that's considered a cash instrument, and you have to declare that, or else you're going to be a CBP customs violation. Two other quick notes. So I've done a video and talked about this already, but there is a situation where CBP is checking phones and people are worried about this. The rule is that if you have something on the cloud, they can't access it. So what CBP does is when they get your phone, if they're going to look at it, which is again rare because frankly they don't have enough manpower with the millions of people visiting the US every year. So when they do is they put the phone on airplane mode so it doesn't have access to Wi-Fi or internet, and that way they can't check the cloud. And then they check your phone, whatever's downloaded, because in essence it's like checking your luggage. And then, you know, there's the issue, what if I have a password on it? Well, the reality is a password is similar to a lock on a suitcase. They can bust open that lock if they want to check stuff inside it. It's the same as your phone. You could fight it, challenge it, but you know what? They can just hold on to the phone and not give it back. Essentially, the key is this. Don't have anything on your phone you don't want seen. Keep it on the cloud. That's the way to go. But be mindful, like in my Gmail account, although it's technically on the cloud, my most recent emails are on my phone. So even if I go on airplane mode, I can check my like 10 or 20 or 30 most recent emails. So those could be accessible because they're technically on the phone. Just something to be mindful for. Finally, you know, I'm getting more and more of this, but of calls about people getting expeditedly removed or sometimes permitted to voluntarily withdraw their entry in the U.S. In the past, CBP at the X office and other ones have said that, you know, if something happens, contact us. If we feel like it's an incorrect expedited removal, we'll try to fix it. Now, almost all the time, expedited removal is correct, and I agree with them. That's what they were saying. You know, it's rarely, if ever, has been wrong. From the calls I've got, people have been saying, yeah, I told the officer I'm coming to the U.S., get married, and stay here. Or I'm coming to the U.S. to work and make money, then go back to my home country on a tourist visa. So there's like no chance that's going to be fixed. But the reality is this, there's no formal legal regulation or mechanism that permits CBP to review expedited removals. So what happened is old school officers were taking on their own to try to fix issues and be nice about it, but they're cutting that out because that's not the proper way to do it. They told me that they're working with, you know, the council and all that, legal counsel internally on them to figure out a mechanism, but right now if you're expedited removed, you have to deal with USCIS or the State Department. I guess going to State Department at a consular interview, requesting a waiver of like to fix that. But you can't go directly to them and fix it. I mean, you can always give it a try, contact local CBP and see what's doable. But that's what they're telling me. Hopefully in the future something will pop up. So moving on from that stuff, there's a lawsuit happening on the international entrepreneurial rule that Obama put into place. It's been put off for now. People are suing, saying we're expecting this international entrepreneurial parole program to kick in, but it hasn't, and it seems like Trump's just not having it. So we'll see if that comes back and what happens with the suit. I'll keep you posted. The EB-5 Regional Center was reauthorized until December 8, 2017, so they're kicking the can down the road for another 6 months, or less than 6 months, really, every 3 months. I really hate that. I kind of wish at this point they would just make a final decision, because my consultations on EB-5 are terrible. I say it could be A, it could be B, it could be C, it could be D. There's no certainty with what advice I give people. And it's not good having a law like that. It's not a good representation of the lawyer giving that kind of advice, so it kind of sucks. Moving on, the TPS status for Sudan was extended for 18 months, but they said it's a last increase, and after that they're going to cut it out. Sudan was also taken off the list of the travel ban countries, interestingly, as well. The next thing that I want to talk about is a court case that came out. It was a matter of NAI number 27 INN December 72. It happened a couple months ago. I've been putting it off. I wanted to talk about it briefly, but I couldn't get access to the court case until this week to be able to read it. Actually, this and another case. They said that if you're an asylee and you adjust status and then something happens where they want to remove you, you've lost your asylee status. So you can't back it up and say, okay, I lost my green card, my LPR status, now I'm an asylee. No, the second you transition from asylee adjust status to become a lawful permanent resident, at that point, if you go to removal, you can't fall back on the asylee status. Now, maybe you could file for cancellation or removal or something like that. That might be the way to go. That's what the court ruling in that case said. There's another case, and I forgot to write down the citation for it, but in cases where someone's born and they don't have their birth certificate actually issued or registered within a few years after that, or immediately, it goes a little bit more time after that, there was a challenge saying the birth certificate is not valid by the U.S. government. And the court said in this case that it's got to look at it on a case-by-case basis. Some countries, you can't get like your birth certificate at the same time. It might be some time after that. You got to look at several factors, like how long it took for the birth certificate to be issued, if there's affidavits from people that are witnesses, if there's secondary documentation, the reasoning why something like this would happen. All these various factors go into place to compensate for the fact that the birth certificate, although issued, occurred several years after or sometime after the actual birth occurred. So if you have clients, always look to see the issue date of the birth certificate to make sure this issue doesn't exist, because that's going to be additional work for you if USCIS looks at it, for example, in adjustment of status, and says that, oh, we don't accept this birth certificate. Well, then you just added hours to 3 hours additional work preparing a response for that. So in the initial consultation, do that. Honestly, something that popped in my head, there was this Facebook group, they were talking about, consultation fees and, do you charge, or explain why you're not charged. And someone said, all I need is 15 minutes with somebody, I can tell them exactly what they need and take it from there. Technically, at 15 minutes, I could get the basics of what someone needs and quote a price. But in my experience, one is, I need to just talk with them about who they are to see how much time they're going to take and how responsive they are, and to pull out little details of information that could help the case. And also, I need to review their documents and spend time like this. I've seen people say I have a valid visa, but they enter it unlawfully. I've seen people who say I have a birth certificate, the birth certificate has someone else's name on it. There's all these little issues where if I give them a quote right then, and then later it pops up that it can't, it's going to be a problem, especially if that 15 minutes, on the phone, I say, okay, you're good to go, call me back and we'll set up and get me started. Client said, oh, okay, I talked to the lawyer, I was going to file myself, and they file, and all of a sudden they get denied because they didn't actually review the documents, so they had a mistake, and I didn't either, I just told them over the phone. It's not the thing to do. As much as it annoys clients, and I just got a bad review last week because this guy was calling around lawyers, and he left a bunch of bad reviews for a bunch of immigration lawyers in Los Angeles saying, I have one question, no one's answering me. The guy asked a very complicated question that I'm not going to answer over the phone in 5 minutes without meeting with them and talking it over, and he took it out to leave a bad review. Well, whatever, I'll have to do an explanation, explaining why the situation happened, that he wasn't my client, that I didn't have a consultation, and he's just being unreasonable in what he's asking for. But, so be it. If I got to get a bad review, I'm going to get a bad review. Either you do the job right and fully, or you don't do it at all. You don't want to mess around with people's lives. We're like their doctors. You can't call a doctor and say, like, how much is surgery on my nose? And the guy says, okay, this much price. Nose surgeries happen all the time now. It's cosmetic surgery for a lot of cases. Most people are okay, but you might be one of those cases where you'll die if you get nose surgery. Now, the issue with nose surgery is you still have to go to a doctor to do it. With immigration, if we give somebody the phone, people will think they're really fancy and go do it on their own, and then they'll have a big problem. So we just can't mess around with throwing around legal advice. And something I have to be conscious of this podcast, and I put this disclaimer out there. This isn't legal advice, and it's not for non-immigration lawyers. This is really a professional broadcast for us to talk about issues. So that's just a pet peeve or something of mine that it's really important. It's very hard to get used to the fact at first when people call and have to shut them down. Now I have no problem. At the very beginning, they call, I have one question. I say, listen, I can't give legal advice to the phone. Generally, what is your issue? Very briefly, in 2 sentences, and it always goes to a paragraph, but 2 sentences, let me know. And I try to get it there and then give some general guidance about what the situation is. But then I tell them, listen, I have to meet with you. I had one person the other day, is like, you'll get your money. I'm like, dude, it's not about the money, my consultation fees, honestly, if I lose that amount of money out of my pocket, I wouldn't even trip about it. The issue is I want to do it right. I don't want you to have problems. Either I'm going to do it right or I'm not going to do it at all. Because I've seen way too many disasters coming to my office from other cases where the attorney did a terrible job or didn't do the research or gave bad advice or just did a quick phone call they thought they could do on their own. I'm not messing around with people's lives. Either I'm going to do it right or not do it at all. It's got to be the motto when it comes to immigration practice. If you want to do pro bono consultation, say, listen, I've even had a case, recently, I had last week. It was how much detail here? I said, listen, you're an alumni of my school, come in for free, I'll have a full consultation for you, no charge. And they kept wanting to ask questions on the phone. I said, listen, come, I'll spend an hour talking with you. And they came, it was a good guy. But I said, I don't want to not see you, I don't want to not review your documents, I really want to have it all in the wraps where I get a decision. It's not about the money, I've waived the fee on the consultation. It's got to happen like that. So that's it. If you want to get 15-minute phone calls, I would say meet with the client and review all their documents and give them that follow-up email that breaks down everything. Either do it right or don't do it at all. Last thing to leave with, which is a very sad case, I had someone contact me about humanitarian reinstatement. They went to the Vietnamese embassy 3 times, they were denied. I don't really do humanitarian statements, so I give the info for other people to contact that do. And they contacted me last week saying, the issue is the foreign family members, a sister, want to come to the U.S. for medical purposes to give like bone marrow to save the dying mother of the person that called me's life, the sister of the foreign national. And the person's just wasting away, there's no time. And the U.S. Embassy keeps denying the visa, even though the doctors in the hospital, everyone wrote stuff, they did tests showing the bone marrow or whatever the situation with the cancer matches that could fix them, stem cells or something like. But they keep denying the visas. Eventually they got ABC7 or ABC in Southern California to do like an online report on it. I've been contacting Associated Press, KPCC, all these different organizations, trying to get them to talk about it. But so far, nothing has moved forward additional to that. It's a very sad story, and unfortunately, I've been so slammed this week that just with clients needing emergency situations that I wish I could have done more time to try to push the issue and get in the limelight, especially because they're okay with people talking about this. But it's just a hard situation when the visa, the consular processing becomes so difficult. Visa, I guess, in Vietnam is a high fraud post, so they're very hesitant in granting visas there. But I mean, they filed for themselves, so I didn't see, honestly, I didn't see what they submitted to the embassy. They might have sent them documents not well written or not explained or not prepared. That's something that does happen when people do on their own. It's an easy case, but they do such a terrible job to go through. I haven't seen that. But either way, if they have medical documents and the consular officer could easily call the doctor in the hospital to check on these things, it should have been something that's approved. So, just something I wanted to talk about that we all deal with in this practice. It's very sad when we can't make it happen, or there are just some things that block our way. Sorry to leave you on a sad note, but I'll go back to a reminder of my Facebook page. Now, please email me if you need help finding a link, info@jqqlaw.com. The Facebook page is, I think, Facebook. It's new, so I'll remind you of exact name, but it's the Immigration Lawyers Listserv. It's the same listserv that's a companion to the podcast where I have different regions, and you could, if you have a lot of Iranian clients, you can join the Iranian group where you talk about cases processing in Iran. If you deal with a lot of European cases processing there, South Asia, Southeast Asia, all this like. I have that listserv group that's on Facebook, and I'm launching that and making it more active with just information primarily of what we're doing and processing times for E2 in whatever country, or if you have the E2 instructions for Belgium or in Brazil and stuff. I really want to post that stuff out there as a resource that stays there and you can do searchable to find to make it easier for all of us. Thank you so much for listening again to this episode of the Immigration Lawyers Podcast. I'm John Khosravi. I look forward to talking with you all next week. Bye-bye.